Hello. Yes.
I know if you're busy, it'll take 2 seconds, just clarification. So I was hired by an individual that has an assault case, it's a pre-file. He subsequently had another case,
Mhm.
I guess prior to, that was an interviewing with child custody.
Mhm.
And when he picked up the new case, you alternated his bond conditions for partial house arrest.
Mhm.
There was an agreed motion between, I guess, the state and the defense that he had at that time. But he has farm animals and wanted to see if
I'm sorry, just 1 second. I've been waiting for this phone call from
No,
the
no, no, no,
senator.
no, no.
Just a second. I'm sorry.
the information had previously
Okay.
been filed. And it's, the only reason I ask is, I don't mind setting it for a hearing.
Mhm.
But it's not to necessarily remove the ankle monitor at this time, even though
So what do you want? What do you need?
he would like to leave his house to feed his farm animals and go to the grocery store if possible. If you need to have a hearing for that, we can certainly do that. I don't feel like it's unreasonable. request.
All right, so the feeding of the farm animals. Are you aware of this? Thomas Lozano, he wants to be able to feed the farm animals.
I know they had a trial that they were.
Yeah, Your Honor, we haven't seen the motion or anything, so we just haven't had a chance to look at it. I was
Yeah,
asking
so-
the defense attorney to maybe come back in a day or so so that we have a moment.
All right,
to
will
look
the
at
farm animals die in that time?
I just wanna make
He
sure.
hasn't-
Don't they need to eat every day?
I didn't know what the motion consisted
Oh,
of, if it's
oh,
something,
He says
urgent,
farm animals.
Look at it.
Yeah.
I don't want.
So if you want to talk to them, so we can leave the grocery store off the table. Since yeah, the most important thing is feeding the
Definitely.
farm animals.
Sure.
So if you want to talk to them about the feeding of the farm animals, because I'm pretty sure, I could be wrong, but I think they need to eat maybe every day or at least every other day.
I would,
And the main thing for me is if I come back on Thursday, can my client's appearance be waived or does he need to be present before
By
that?
Zoom.
It's by Zoom?
You can come by Zoom.
Okay. Give me objection. And I don't have
Oh.
the actual motion. This was the original motion. I know, I didn't want to vote.
where, yeah, it's urgent. I can look at it.
Joseph Mejia. Who's on Joseph Mejia? Deputy Lord, farm animals, they do have to eat every day, don't they? Can we go a day without eating? I don't think so. I know I can't. I'll do it if it's a zombie apocalypse, but. All right, so we're here today for a jury trial.
Yeah.
Okay.
The state is not ready and we would actually, tendering a dismissal of this case.
Okay. All right, so they're dismissing this case.
We have no objection.
They say that it is because a witness is missing. So I appreciate you. Oh, everybody's just, it's a party, but no appetizers. All right. So what you need to realize is that whatever reason brought you here today, the state is dismissing this because they say they don't have their witness, right? So if you have an anger issue, you need to take care of that. If you're ever in a relationship and it gets to the point where you want to put your hands on someone in any other way, but in a loving way, then it's time to leave. And maybe that's not a good relationship for you. And maybe you have anger issues that need to be solved. You understand? Because what you're charged with, the range of punishment on this is 2 to 10 years in prison. You understand? All right. Thank you for dressing appropriately for court. And I'll sign the dismissal.
Thank you.
Okay, but for the record, I take back some of the things I said with the Judge Martin.
He always says. Thank you.
Thank you. Bye-bye.
Bye-bye. Alexander Rodriguez. Good morning. Your file was actually connected to somebody else's. That's why I didn't see it.
Oh, it hasn't been that long. You're good.
How's it going?
Good. How are you?
Oh, good. I can't complain.
Happy New Year.
Yeah. Oh, yeah. Happy New Year.
Okay.
You know, you would, back in the day when you would write checks, you would always mess up so many checks because you would forget to put
The
the new
old
year.
year. Yep.
All right. So on this case, the last time we were here, there was for discovery, further investigation needed, plea deadline date. So have you all worked out an agreement or no?
No, Judge, we do not have an
All
agreement.
right. Do y'all need a jury trial?
We do.
How long do y'all expect this trial to last?
A week.
All right, Ms. Ferguson, I need a jury trial setting, family violence 1 week.
Can I step away to get my calendar?
Sure.
Thank you.
All right, she's gonna grab her calendar. Let's see where we are.
April 8th.
Is that what you said, Norma?
Yes.
The 8th? Okay. We actually have a civil jury trial that week, but criminal trumps civil.
Yes.
Okay.
All right, so we'll put it on April 8th, and if you could sign a acknowledgement of discovery before you leave.
Believe it's already been signed.
All right, because I don't have it. They went
Okay.
100% paperless. So if
Okay.
you'll make sure that the clerks have it.
Yes.
And they're gonna bring you over dressed for trial and whatever civilian clothing you have. So
It will be
It will
different,
be
Judge.
different, yes.
We are aware.
counsel, if there's an issue with the clothing exchange, just let me know and I'll see what I can do to help expedite it.
Thank you, Judge.
Do you have any
Appreciate it.
questions? All right, we'll see you then. Thank you.
Thank you, Judge.
Thank you. Lisa Pryor. Hello. All right, so on this case, let me see what I have here.
Yes, Your Honor. And, this is the one with the child recommendation for the year. It's essentially been,
Okay. So what happened with because I had ordered the felony drug court, I know they're full.
Yes, Your Honor.
They won't have room until the beginning of February.
Yes, Judge.
If you all want, we can wait on that. I don't know if the MIC evaluation has been completed.
It has, Your Honor. That's correct. The recommendation from Community Supervision is DDRF, Judge.
Okay.
Ms. Zapata notified me that it's about a 2 to 8 week wait on average. Last time we were in court, I did seek some alternatives to
Mhm.
possible extended DDRF stay, Judge.
Mhm.
She suffers from substance use disorder and she was interviewed by PICU. And she met criteria for paid for it at Haven for Hope, Judge. I know I spoke with Bashan about it last time, and she had a concern of whether people with mental health issues can in fact participate at paid for it.
Mhm.
And I followed up and they stated that they could accommodate her, Judge. Our concern is that she has housing issues too. So we feel that the paid forward program at Haven for Hope can address her substance use, get her coordinated with Haven, and possibly move up within Haven to get stable housing, Judge. We don't, and I know the court's concern is they don't want her released to the community where she doesn't have the resources, reoffend and MTRs triggered. Ms. Pryor has been in custody, waiting us to meet here in court, Judge, and we were just asking respectfully if she could be considered for paid forward. I did get confirmation yesterday that she does meet criteria, and I did forward that to the court as well as representative from the prosecutor's office.
All right, are you currently on your medications?
Yes, ma'am.
All right, do you have a phone or the ability to call someone once you're released?
Yes, ma'am.
All right, so this is what probation with her, this is what I'll require. We're gonna see if pay it forward at Haven is gonna work. So I'm gonna require that she call into probation upon release. You're gonna call into probation once every 2 weeks.
Yes.
Because the concern I have, what I usually find at Haven for Hope, when persons have a combination of that plus mental health, they end up falling off the radar and probation can't get in touch with them. So you're gonna have to call them once every 2 weeks to say, here I am, right? And that's gonna be in addition to her reporting. If you all want her calling to you once every 2 weeks as her reporting, the court is fine with that. Just as long as you all make sure she is still in the Pay It Forward program at Haven for Hope.
We don't do the phone recording anymore, but what I'll just notate is if possible, we can always facilitate like a Zoom meeting or something to that effect. And I think Pay It Forward has been pretty amenable to making accommodations for that.
Okay. Is there anything else you need?
No, ma'am, none at this time. Thank you for the opportunity.
Oh, you're welcome. So your attorney will tell you in this court people are placed on probation. I'm hoping they're going to be successful. If I didn't think you could be successful, I wouldn't have gone through with your agreement. So communication for you is going to be very important. Communication with your doctors, with your probation officers. If something happens and you feel you can't get in touch with probation, you can always come back in here. You can always call your attorney and we'll see what's going on.
I have one question.
Sure.
After this is completed during this process, I've lost my home.
Mhm.
Okay, we're gonna be helping with that situation.
Yes.
But if, after I complete this program, and things like that, to transfer my probation to another county because I've lost my home, would that be something I need to come
Yes.
back to you to or
Yes.
to?
What will end up
probation?
happening is once you're stabilized in the community, probation will send me a request for you to transfer to another county. But I don't just send people to other counties unless they have stable housing and everything else.
Right, I understand that.
Yes.
And Judge, Ms. Pryor was awaiting a final Tacoma evaluation in custody on January 28th. Would you like us to continue with that on bond? And-
Yes.
Okay. That way we can cancel it and then I'll just have them set up a new appointment for her.
All right. So you'll probably be released at midnight. That's what they do. Why? I don't know. I have no control over that, but
Your Honor, with regard to that, PICU did notify me that if the court did allow her to do paid forward, to get with them to coordinate a release plan, Judge. So I can go ahead and notify them that Your Honor graciously allowed her to do the program to better her life and then ask that maybe not a midnight release, but something more during daytime hours, because
Yes.
I know that they're gonna need to transfer her directly from custody to that paid forward and follow all the rules and regulations there.
yes.
Sure, I'll go ahead and
Okay.
do
All right. Thank
Thank you
you.
so
Thank you, Your Honor. Maybe
You're
excuse.
welcome.
Second signature.
Yes.
And vote you again.
All right.
So the state has no objection
Yes.
to feeding farm animals. Do you need me to file something formal or can we write it maybe on?
You'll have to write that in and write the hours in and both of you will have to sign off on it.
Okay, but, okay,
Yes.
fantastic. So what I will do is I'll find that out, I'll file it and I'll have it e-filed with you guys.
Sure. Or either if you will email it to them because
They'll be
when it is
faster.
e-filed, sometimes it gets lost in
I
the
know that.
atmosphere.
So I'll email it to the court. The
All right.
clerks, should I just check out the clerk?
Yes, or either Ms. Ferguson and she'll make sure I receive it. But include the probation officer in the email.
I will do that.
Jose Amador.
Nancy.
Where's the attorney for Jose Amador? Okay. Oh. See, my glasses are for distance.
Mine too.
And you know, I got fitted for contacts. I've always worn contacts in the past. And so the guy was telling me, because I said, well, it's a problem because when I want to read something, I'd have to do this.
Oh, yeah.
And he said, oh, no. He said, in your dominant eye, you wear a contact. And in your non-dominant eye, don't wear a contact lens.
But my dominant eye is the word with my teeth.
All right, we're going to go on the record. Court is calling 2024 CR 3037 and 2024 CR 3038. State of Texas versus Jose Amador. Can I have parties announced?
I think I'll wait for the state.
Orlando Castañon for defense.
And are you Mr. Amador?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the document entitled application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
I do.
State, and the cause number ending in 37, are you proceeding on the indictment as presented? That is the aggravated assault with a deadly weapon and a failure to stop and render aid.
So on that one, Your Honor, we have to proceed on counts 1 through 4, and we will waive the abandoned parameters.
We have no objections.
And in the cause number ending in 38, are you proceeding on the indictment as presented?
Yes, Your Honor.
And both cause numbers, did you review the admonishments with your attorney? Did you understand them and sign them in all the appropriate places?
Yes, ma'am.
All right. And the cause number in 3H, you're charged with evading arrest, detention with a vehicle. Range of punishment is anywhere from 2 to 10 years in prison and a possible fine up to $10,000. If the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you to 10 years in the prison and up to a $10,000 fine. And the cause number ending in 37, you're charged with aggravated assault with a deadly weapon in counts 1, 2, 3, and 4. The range of punishment for those charges is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If I were to grant your application for deferred adjudication under that cause number, if for any reason your deferred adjudication were revoked, and each of those counts, the court could sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
I left the deadly weapon check on it.
No. Yes, that's one of the issues. And then this one has 1 through 4 and there's
I
only.
did note that it was on the evading. It should just be.
Okay.
There's only one count.
Mr. Amador, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, in 37, the state is proceeding on counts 1 through 4. In each cause number, your punishment is to be assessed at a cap of 4 years in the prison. There's a $2,000 fine. In the cause number ending in 37, there's an affirmative finding of deadly weapon in counts 1 through 4. The state is silent on your application for deferred adjudication. The cases will run concurrently. The state will take in consideration 2024 CR 2939 and 2024 CR 3039. Did you understand that to be your plea bargain agreement in each cause number?
Yes, ma'am.
Defense is at the plea.
It is, Judge.
State is at the plea.
It is. Your Honor.
Did you review the waiver of appeal paragraph in each cause number with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then in the cause number 2024 CR 3038, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2024 CR 3037, how do you plead to count 1,
No contest.
count 2,
No contest.
count 3,
No contest.
count 4?
No contest.
Oh, and also in the cause number ending in 37, I'm assuming that you are asking that these counts run concurrently?
Correct.
All right, any objections
No
to
objection,
me
Judge.
including that in the plea bargain agreement?
Yeah, Your Honor.
None from defense.
All right, state any evidence to support the defendants, please?
The state offers states exhibit number 1 and attachments in each cause.
No objection, Judge.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Well, I guess it doesn't necessarily say that inscribing it, just that on the third to the last paragraph, there's statements in regards to
All right,
The-
let's just see it.
talking that they were injured.
I'm printing an additional one out that further describes Stephanie's Hampton, but with
Okay.
what were the others that I know? you
Well, see,
didn't-
I see Mata is in here. Stanton is in here. I don't have Jaden Villarreal. I'm looking for that person and Gomez.
That you're looking in regards to Virial, correct?
Yes, Villarreal and Gomez.
Go, man.
That's, what was the first name on the judge?
I think it's Leonardo or Leonard.
We'll just go ahead and amend her. Just go on to.
Okay. So you all are proceeding on counts. I'll tell you which ones I found. Counts 1 and counts 2, those are what you're proceeding on?
Yes, Your Honor.
All right.
We have no
any
objections to that,
objections?
Judge.
All right. Then in each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. With regards to sentencing, if you all would like, I can do a PSI. The PSI will probably be about 8 weeks. Or if you all just want me to proceed on his criminal history and any other witnesses anyone wishes to call, I can reset it off for an earlier date. So
I have no objections to that because, you know, his criminal history is minimal, so.
okay. All right. So when do you all want to call it back?
I can come back 2 weeks from now.
All right, Ms. Ferguson, can you recall Amador 2 weeks for sentencing?
Yes, sir.
All right. All right, we'll be back on January 30th. On January 30th, I'll make a decision on your application based upon any evidence that's presented.
Thank you, Judge.
All right, thank you. All right, Lorraine, do you want to take Mr. Jaiki? Because, yeah, let's do that so that the jail can do their thing. Because Mr. Jaiki, I want to make sure that you get your lunch. Could I see the file on Jaiki, please?
Yes, ma'am.
All right, this is going to be the last case and we're going to take our break and then we'll come back in the afternoon with the jury.
Can you help us finish these?
All right, who's ready?
We're working on paperwork for Louis.
Okay,
Over this close.
all right. All right, so everyone, we break for lunch, but the deputy is asking me to continue. So does anyone have any objection with continuing?
Not from this family violence portion of the statement. No objection.
Defense attorneys? Okay. You ready on yours?
Yes, sir.
All right, because I have a judge's meeting at 12:30.
Yes, sir.
All right, if I could have the information on Rodriguez, please. Is it Antonio Rodriguez? All right,
91.
all right, so, hi, how you doing? So of course, we're trying to get you the help, but there's a Takami evaluation. So the issue is that you're currently have a parole. Have you had your parole hearing yet or no?
Not yet.
Have they given you a date for your parole hearing?
No, not yet.
Okay. So the problem is we can continue with the evaluation for February 4th, but I'm going to need to have an attorney for you, see what we can do about your parole matter to see when that's set.
Okay.
Because otherwise you're going to be in limbo.
Mm.
Because they're not going to accept you if you have an open case and you're pending a parole hearing.
I see.
So have you had any contact with your parole officer?
No, I was just notified on Friday about it.
All right, so I wanted you brought over so we can let you know what's going on, so you would not be thinking, hey, why hasn't anything happened? So what we'll do, let's keep him on schedule for the Takami evaluation on February 4th. Of course, if they end up revoking your parole, then you'll have some decisions that you'll need to make with regards to this case. Okay? And those decisions will be whether or not, if you're revoked on your parole, do you still want to continue with probation for this case or not? That'll be something that you'll need to discuss with an attorney. All right, so we'll keep you for February 4th for the evaluation. And can you let Takami know? Please don't just say we're rejecting him because he has an open case.
Okay.
Let us know if other than that being an impediment, would they accept him? Because somebody may be able to take care of the parole hearing very quickly.
And did you want to bring him back for another compliance hearing?
Yes, let's bring him back after we get the results. What do you think would be a good date, Caroline? All right, so we're going to bring you back to court on February 10th. And the reason why you didn't have an attorney present is because this is just a compliance hearing. I'm not taking any evidence. But if there's something still going on with the parole, we'll make sure to see if we can get an attorney that maybe can coordinate with that person. All right, thank you.
Have a good day.
All right, you too. All right, are we ready on Martinez? All right, court is calling 2020 CR 9620 and 2022 CR 5934W, State of Texas versus Carlos Martinez. Can I have parties announced for the record for the state
I'm Galloway for the state.
defense?
Nipa Gallegos Carrillo.
And are you Mr. Martinez?
Yes, ma'am.
And each of the cause numbers, did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it? Are you the same Carlos Martinez Jr. who's placed on community supervision in 2022 CR 5934W for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on June 16, 2022 for a term of 2 years? And are you the same Carlos Martinez Jr. who was placed on community supervision in 2020 CR 9620 for the offense of felon in possession of a firearm on June 16, 2022 for a term of 2 years? Is that you? All right, state, are you proceeding on the same allegations in each motion?
Yes, Your Honor, and that's violation of condition number 4 in Bexar County, Texas. The defendant, Carlos Martinez, did then and there fail to report to the supervision officer as directed for the months of August, September, and October 2022 in violation of condition number 4.
How do you plead to that, true or not true?
True.
And that's true in both motions?
Yes, ma'am.
All right. And state, are you proceeding on the other allegations?
He waived and abandoned.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4 and cause number 2022 CR 5934W? The court could sentence you up to 2 years in the prison and up to $1,000 fine? And did you understand by pleading true to violation of condition number 4 in 2020 CR 9620? The court could find it true and sentence you up to 2 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4 in each cause number?
True.
Do you wish to proceed with your plea of true? And each, yes, that's yes or no?
Oh, yes.
All right, then in each cause number, the court, that's okay. In each cause number, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you grant the state's motion to revoke the defendant's community supervision and sentence him to his underlying 2-year sentence in each cause. The reasons being that the defendant has not reported since the year 2022. He was set to expire in June of this year. However, he has completed nothing on probation and absconded from the jurisdiction of his court, and so we would ask that he sentence him to 2 years.
All right, defense, what are you asking for?
Your Honor, we're asking the probation department has asked for Your Honor to extend him, give him the opportunity to do the, extend him for 2 years and to, so they can have the 2 years, him on probation. And that's when we ask your court, the judge to honor that.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Carlos Martinez.
Why were you not reporting?
I was working out of town.
Were you given permission to work out of town?
No, ma'am.
Then why didn't you pick up the phone and call probation or ask, can I work out of town?
I don't have no excuse.
Okay, any other questions?
No, Your Honor, I just, what I asked that, given the opportunity to do the probation. Of course, I'm under the impression that he's been terminated already, or has he terminated his term?
No.
Not yet? Okay. And so, I asked then, okay, because you can't give him less than 2 years.
All right, let me ask this of you, sir. Have you completed anything on probation?
No, ma'am.
All right. Okay, thank you. In each cause number, the court, as previously stated, is finding violation of condition number 4 true. The court is going to grant the motion, revoke. Within each cause number, the court will sentence you to 2 years in the prison, give you credit for any time served. And cause number 2020 CR 9620, there's $1,000 fine. And also there's $1,000 fine in cause number 2022 CR 5934W. time and money will run concurrent and each cause number will run concurrently. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You do have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are in community supervision. Do you understand? Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
And Your Honor, he has two different, cases, which have two different, time that he has served. And I want it on record that I think that the oldest one for 2020 has 91 days. And for the second offense, he has 73 days. At least that's what I was informed by the clerk.
Sure. And the clerks will make sure that the correct amount of time is given. If you think it is incorrect, just let the clerks know and we'll correct it.
Yes, Your Honor. Thank
All
you.
right, thank you so much. Have a good one.
Thank you.
You're welcome. You're welcome. Okay,
Thank you.
Everybody else come back at 7:30, sir?
yes. And then if you could, we'll need Mr. Dykey back too. All right. Okay. All right, we'll be back at 1:30-ish. All right, Mr. Dykey, we're gonna have you back at, oh, she just zoomed in. So I'm gonna put you in a breakout room with your attorney. Okay,
real quick.
all right, when you all are ready to do that, let me know. And then, sir, what's your name? All right, Antonio Rodriguez. If you'll come forward. All right, so with you, it's regarding the GPS
Yes, ma'am.
and you're asking for it to be removed?
Yes, ma'am.
All right, who's the hi,
Probation.
thank you.
Revocation.
All right, so who is the prosecutor on Antonio Rodriguez?
Sorry, what judge?
On Antonio Martinez Rodriguez, are you all on that, the stalking?
Judge, maybe.
All right, so if you'll have a seat, we're gonna get to you. I just need them to look over to see if they have any objections. Mr. Rittenhour, is he only pleading to one case? Is he only pleading to one case? Is he only
One.
pleading to one case?
No, two cases, Judge. I thought you said count, there are two cases.
Is he pleading to both?
Yes, he is, Judge.
All right,
And we're gonna ask for a PSI.
all right. Court is calling 2024 CR 4764 and 2024 CR 4765. State versus Luis Martinez. Can I have parties announced for the record for the state
Sanders, Office of State.
defense?
But written hour for the defense.
Are you Mr. Martinez?
Yes, ma'am.
Counsel, have you received all discovery in each of the cause numbers?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, is there an application in either of these cases?
No.
All right. Mr. Martinez, in each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding with the indictment as presented and the cause number ending in 6-4?
6, no, we are not. We are waiving count 2 and proceeding on count 1 on the lesser included offense of aggravated sexual assault of a child.
That's our understanding, Judge.
Any objection?
No objection.
And are you proceeding with the indictment as presented in 6-5?
Yes, we are, Your Honor.
And each of the cause numbers, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. And with the cause number ending in 6-4, the state is proceeding on the lesser included offense of aggravated sexual assault of a child. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And cause number ending in 6-5, the state is proceeding on indecency with a child by sexual contact. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you understand that?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Martinez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of the cause numbers with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the cases are to run concurrently. There's to be Chapter 62 registration. And the cause number ending in 6-5, punishments be assessed at 2 years in the prison. And cause number ending in 6-4, punishments be assessed at a cap of 15 years. The state is proceeding on the lesser included offense of aggravated sexual assault of child in count 1. There's a $1,500 fine in both cause numbers. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
That is, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Do you understand?
All right, get one back.
All right, so here's the thing. Your attorney would have to file pretrial motions with the court. Sometimes those motions are, I want a witness list. I would make a ruling on whether or not he obtains a witness list. Or sometimes that motion could be, I don't want a specific witness saying something. It could be any type of motion. Do you understand that?
Yes.
All right, when you enter into a plea bargain agreement in these cause numbers, you are waiving or giving up your right to appeal. So you can't come back and say, you know what? I've changed my mind. You understand?
Speak
The
up.
only exception to that rule is if your attorney has filed some motions, I've ruled on them, and then you can appeal my ruling for those particular motions. Say, for example, if he filed a motion and he believed that he was entitled to something, and I said, no, you're not entitled to that. And you go to and you enter this plea. Well, you can still appeal because I didn't give him something he said he should have had. You understand? And that's just a hypothetical. Do you understand?
Yes, Your Honor.
All right. Outside the agreement, the state wants you to have no contact with the complainants. Do you understand that?
Yes.
Those are recommendations from the state. The court does not have to follow those recommendations. Do you understand?
Yes.
All right, then in cause number 2024 CR 4765, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2024 CR 4764, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers States Exhibit 1 and all attachments for both cause numbers.
We reviewed the documents and have no objection.
All right, did you review the documents entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty, and the court will also find you guilty, and I'm sorry, The court will also find you guilty in 2024 CR 4765. And my understanding, you're wishing to have a PSI?
That's correct, Your Honor.
All right, can I get a PSI date, please?
March 6th.
All right, we'll be back on March 6th.
6.
Do you need a TAP evaluation with that or no?
No, I don't.
Okay. All right, we'll see you back on March 6th, and I'll make a decision on whether or not I'll follow through with your plea bargain agreement.
PSI only, correct?
Yes. All right, do y'all need to put something on the record for Mr. Nichols?
Yes, Your Honor.
Yes, the one thing outside the presence of the court.
Oh, does it need to be outside the presence? Because I'm not doing punishment. If we were to get there, it's the jury, unless y'all are changing your mind on election for punishment.
Excuse me, Your Honor.
Where you
Do
at?
y'all maybe need to meet with me tomorrow instead?
14R, 14Q is right there.
Oh, no, you said March what? Oh, well, then we're not ready to bring you in. I'm sorry, when?
But actually, Judge, I think he is going to elect the court.
Is that correct, sir? All right, then, when you're all ready, I'll step out so you can put whatever you need to put on the record.
We haven't filed it yet. Well,
Mr. Jockey, there have been some issues with the sound. Deputy Laura and Deputy Mejia, can you just have him brought over for Thursday? And we'll have you brought over for Thursday to take care of that.
Okay, thank you very
And your
much.
attorney is about to start a jury trial as well.
Okay, thank you very much. I'll see you then.